Hi, everybody. This is Tim Franczyk from the Assigned Counsel Program, and I'm happy to be with you, at least remotely. Hopefully, before too long, we can get together again in person and have a chance to interact with one another. But for the time being, I thought what I would do is to present a little mini tutorial on a specific rule of evidence. I hope you've had a chance to read some of the articles that I've been putting out through the Assigned Counsel Program over the past several weeks. Hopefully they've been of some value to you, if not as a legal resource, then perhaps as a substitute for Somonex if you can't get a full 8 hours sleep on any given evening, but I hope you find them of some use to you. But today I want to speak for the next few minutes about impeachment, specifically impeaching one's own witness. I know that as criminal defense attorneys, you make your stock in trade, so to speak, in cross-examining witnesses, and that often involves attacking their credibility through impeachment, whether by challenging their perception, their memory, or lack thereof, as the case might be, or attack their bias. But oftentimes you have witnesses who testify at trial in a manner that is inconsistent with their prior statements, whether to the grand jury or to the police in a supporting deposition, as the case might be. And so what you do is you confront them with what they said before to highlight that inconsistency. Or perhaps a witness says something at trial that he or she didn't mention, whether in the grand jury, at a felony hearing, or in a statement to the police, and you can impeach them by omission. But what happens and how do you proceed when your own witness goes south on you, so to speak? Well, I guess the answer to that is it depends on how bad the witness hurts you. Now, this most often happens with prosecution witnesses. Why? Because the prosecution has the burden of proof. They call witnesses to testify to make their case, and you get to cross-examine them. So it most frequently happens with prosecution witnesses. So let's say, for example, you have a robbery case of a 7-Eleven store. It happens, say, 11 o'clock at night. And the prosecutor calls a witness who he or she expects will testify that I was there in the 7-Eleven. I saw the person come in, pull the gun, and hold up the clerk and steal money from the cash register. And then the witness subsequently identified the defendant, whether by photo array or at a lineup, and the prosecutor expects, based on that the witness is going to say, here's what happened, and that's the person, meaning the defendant, who committed this robbery. Now, let's say the witness on the stand, however, when asked, is the person who committed this robbery in the courtroom, and the witness says, I don't remember. Whether because the person really doesn't remember, or perhaps has the heebie-jeebies because he or she is afraid, as the case might be, what can the prosecutor do? Well, impeachment is not an option at this point. The best the prosecutor can hope for at this stage is to refresh or try to refresh the witness's recollection by showing him or her the prior statement that the witness gave, allow the witness to read it silently to himself or herself, and hopefully then the witness will have refreshed his or her memory and then can testify based on having read the prior statement. And if the witness is still unable to recall, then the prosecutor may try and introduce that prior statement as past recollection recorded, but that's a very specific foundation that has to be laid. And if the witness is not being cooperative, then there's a good chance you're not going to be able to accomplish that, or at least the prosecutor won't. And of course, if you're sitting there as defense counsel, you're just going to let this go and enjoy it because the witness is unable to identify your client. But the prosecutor has indicated under these circumstances cannot impeach his or her own witness. And that is governed by CPL section 60.35 subdivision 1. And that section says is that you can impeach your own witness if his trial testimony is not just inconsistent with what he or she has said before, but it tends to disprove the prosecution's case on a material element, whether it's an element of the crime, on the issue of identification, which is what we're talking about here, but it's got to be material to the case, not on some collateral or secondary point or issue. So if the witness's trial testimony affirmatively damages the proponent's case on a material issue, then the person who called that witness, in this case the prosecutor, could seek to impeach, provided the witness gave a prior written statement that was signed or gave an oral statement that was under oath. So those are the important conditions that have to be met. And I even have a PowerPoint that I'll share with you. 60.35, it says that the testimony must be on a material issue, and it tends to disprove the party's position in the case, and the prior statement has to be written and signed or sworn and oral under oath, or sworn to, as the case might be. Then you can confront the witness with the prior statement and say, isn't it a fact that in your statement to the grand jury or at the felony hearing, you identified this defendant as the robber? Does that mean that that evidence comes in to prove that the defendant is the robber? The answer is no, because under subdivision 2, the court is required to give the jury a limiting instruction that basically says that that prior statement can only be received for its impeachment value, meaning to highlight the inconsistency with the trial testimony, but it's not substantive evidence of the defendant's guilt or identity as the robber. A couple of cases worth being aware of, at least when you're dealing with this, and they're not particularly new cases, but the first case the Court of Appeals to interpret 60.35 was People versus Fitzpatrick at 40 New York 2nd, 44 from 1976. And then there's a slightly more recent Fourth Department case, People versus Lawrence at 227 AD 2nd, 893. So the court has to instruct the jury then that it's the evidence is admissible only for its impeachment value. Now this is different from the civil scenario, where if the prior statement is given under oath or it's sworn and given under circumstances attesting to its reliability, and the witness is subject to cross-examination, then that prior statement may come in for its substantive value. That's under the case of Latendry versus Hartford, Accident and Indemnity Insurance Company, 21 New York 2nd, 518, from way back in 1968. And the more recent case is Kaufman versus Quickway, 14 New York 3rd, 907 from 2010. But for criminal defense purposes, you should know that if the prosecutor is permitted to impeach his or her own witness, that prior statement only comes in for its impeachment value, and the court must give a limiting instruction to that effect. Hope you appreciate my high-tech PowerPoint here. The rule also applies to the defense. You know, occasionally defendants do call witnesses, put on a case, and let's say in this particular scenario that I've described, the defendant wishes to interpose an alibi defense, and you have interviewed, or your investigator has interviewed a witness. Let's say it's a friend of the defendant who says that at the time of this crime, 11 p.m. on the date in question, the defendant was over at my house and we were watching television or doing whatever. So we got a nice solid alibi. But let's say that between the time of trial or between the time of the incident and the trial, this witness has a change of heart, or there's a falling out between him and your client, or for whatever reason, he's changing his tune. And you call him as a witness, and if he says, I don't remember if the defendant was with me that night, there's a good chance you may not be allowed to impeach that witness, because that's not affirmatively damaging your case, it's just not helping it. Although I think that the courts would tend to be a little bit more lenient or flexible with the defense on the idea that under the Sixth Amendment, the defendant does have the right to put on a defense, and if a witness goes south on you, you'll probably be given some latitude to try and impeach. But let's assume that the witness resides at a location that's about a 15-minute drive, conservatively speaking, from the crime scene. So that, assuming no traffic, to get from the crime scene to his house would take about 15 minutes. And let's say when he gave his statement to the investigator, he says that, at 11 o'clock that night, the defendant was with me. But on trial, he's asked about the defendant being with him. He says, yeah, I think he arrived somewhere around 5 after 11, 10 after 11. Question is, could you impeach him and say, well, didn't you previously give a sworn statement to my investigator where you said it was 11 p.m. sharp? I think that's going to be within the judgment call of the trial court, as most evidentiary decisions are. And unless you establish that time frame affirmatively damages your case, you may not be allowed to impeach your witness. Because you have a 15-minute window, give or take. But what if the witness says that your client arrived at 11:30 or 11:45 or maybe closer to midnight? Now it's shooting your alibi defense to hell. And I would argue, and as I'm sure you would, that would affirmatively damage your defense of alibi. So under those circumstances, assuming your investigator or you took a sworn statement from the witness, or at least a signed written statement, preferably both, you will probably be allowed to impeach. So I hope that gives you some clarity with regard to when and how you can impeach your own witness, but the New York Rule 60.35 is very specific, meaning that there has to be contrary testimony on a material issue that is not just inconsistent or a failure of recall, but which tends to disprove the position of the party who called that witness, i.e. causes affirmative damage, and then the prior statement has to be in writing and signed, or oral statement under oath. Hopefully, you'll never find yourself in that situation where a witness goes elsewhere on you, but people are as they are, and for one reason or another, whether it's passage of time, fear, or whatever it might be, stories tend to change and you need to be ready to deal with it. So I hope that helps. I'm going to follow this up with a song that I hope will put this all in some perspective for you.